morning, everyone. Welcome to another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. I am Carol Williams, and I'm the managing attorney of Williams Immigration. So, I like to dive right in. The first thing I want to talk about this morning is the $100,000 H-1B filing fee that is still in effect. We have some new guidance from USCIS. If you are not aware, several weeks ago, USCIS dropped another Friday late workday surprise on us with a $100,000 fee. The pushback was quite swift, such that USCIS issued about a paragraph's worth of guidance that next day, which would be Saturday. And then they have been fairly quiet since then. Until a couple of days ago, we got some more guidance. So I want to go through that guidance because some of it can be a little bit tricky so far. So the $100,000 filing fee applies to applications filed September 21st and later. And those applications that must pay the new fee are applications where the individual is outside of the U.S. when the application is filed, and that application requests consular notification, port of entry notification, or pre-flight inspection notification. So all of these things are where an individual is outside of the United States when the application is approved, when the application is filed, and then when it's approved, in order to activate that application, they must either go to a consulate and apply for a visa, or they have to go to a port of entry or a pre-flight inspection. So that's sort of the broad category of applications and individuals that are subject to this $100,000 fee. So $100,000 fee applies when an individual is outside of the U.S. when the application is filed and the application requests consular notification, port of entry notification, or pre-flight inspection notification. It also applies for individuals who have filed a change of status, an amendment, and an extension, but they are not actually eligible for those things. They are not eligible for a change of status. They are not eligible for an amendment, and they are not eligible for an extension. So an example, and this is where it gets confusing. An example is if an individual applies for a change of status, but then leaves the U.S. before that application is finalized, before it's approved, then they are really no longer eligible for that change of status. And so then they must go outside of the U.S. and apply for a visa. It was that travel that made them not eligible for the change, but now makes them subject to the $100,000 fee. So change of status, amendment, or an extension, but the Immigration Service finds out that you are not, or determines that you are not eligible for one of those things. That then makes you subject to the $100,000 fee. So the $100,000 fee is not applicable to individuals that have a previously issued visa or individuals that have a currently valid H-1B visa. This new policy does not have a retroactivity to it. So if you have previously been issued an H-1B visa, or if you have been previously issued an H-1B visa that is still current, you can travel using that visa. There is no $100,000 fee that attaches to that. If you file an amendment when you're inside of the United States, that is not subject to the $100,000 fee. If you file a change of status while you are in the United States, that is not subject to the $100,000 fee. Or if you file an extension of status, that is not subject to the $100,000 fee. So for those three, an amendment, a change of status, or an extension, if you are in the U.S., once it's when it's filed and you are in the US, when it's approved, and then you leave the US to apply for a visa. So let's say you get approved in, let's say, January, you don't want to leave until June for whatever reason, business travel, personal travel, and you need to apply for a visa to come back in. You are not subject to the $100,000 fee when you apply for that visa to come back into the US. But that is only if the amendment, the change of status, or the extension of status application was filed while you were in the US. And so just keep that in mind. So that's where it gets a little bit tricky. So that's where there's a lot of strategy that comes into play that maybe previously we weren't so worried about. And we weren't so worried about it because we could always have you leave the US, get a visa, and come back in. Now, if USCIS determines that you are actually not eligible for the amendment, the change of status, or the extension, and you now have to go out and get a visa, that then attaches the new $100,000 fee. So there's much more strategy that will have to go into these applications. So that's the new clarification for the H-1B $100,000 fee. All that said, a lawsuit is currently pending. It's currently working its way through the system. So we will see if this changes at all based on the outcome of that lawsuit. The other thing to note about the $100,000 fee is, unlike the other government filing fees that are part of an H-1B application, the $100,000 needs to be paid before you file. Because proof of payment must be included in the H-1B application. So it is not something where you can fill out the electronic form and then have them essentially run your card for $100,000. That payment must be made before you file, and evidence of that payment must be submitted along with the application. So that is a big difference between the current filing fees for an H-1B and for any other application to this $100,000 fee. Now, there are exemptions. I guess maybe one exemption, I guess, is sort of a better way to think about it. So you can argue that the $100,000 fee, you should be exempt from it, that the individual's application that you are filing for should be exempt. In order to get that exemption, you need to show that what they're going to be doing, what this individual is going to be doing, is in the national interest, that no other U.S. worker is available for this position, that this individual is not a threat to U.S. security, and that payment would significantly undermine the interests of the United States. So to be clear, when it comes to this particular $100,000 fee, none of these sort of key phrases and terms have been defined. So we can make the arguments. It will be up to the individual officer to decide whether or not national interest has been met and what national interest looks like. We can certainly glean what national interest may be from other uses of the term, other uses of the concept within the immigration sphere, but we don't have any sort of concrete definitions in terms of this particular exemption to the $100,000 fee. They haven't told us whether or not we need to recruit for this particular role. Certainly, if we are saying that nobody else is available for this role, maybe showing that you have recruited for this role is helpful. Maybe the role is so niche and so particular that maybe that's enough to show that that nobody else is eligible for and available for this role. But again, it's sort of a little loose in terms of how that's going to be looked at. and significantly undermine the interests of the United States, that is very much not defined for us. So there is a mechanism for requesting an exemption, but just know that as of right now, we don't really have anything concrete to go on in terms of what types of roles or what types of organizations and roles that pairing together that they will consider an individual's role for a specific company to be exempt. So we're not quite sure about that yet. So, but again, all this to say, there is a lawsuit currently pending, so we will see what happens with that lawsuit and if the outcome of that lawsuit as it winds its way through the system will require USCIS to make any changes. So we'll see. And this is going to be sort of a short morning because the last thing that I want to talk to y'all about is this week. This week, USCIS stops accepting checks and paper forms of payment, so checks, money orders. They will accept credit cards. They will accept ACH payments. They have forms online that need to be filled out. So keep that in mind. That goes live this week. So just sort of wrap your heads around it. If you haven't wrapped your heads around it, if you've kept your head in the sand about it, now is truly the time to take your head out of the sand. And if you don't have policies and procedures in place inside your organization, now is the time to rally the troops, figure out how you want to handle that. And also super important, if one person in your organization, no matter the size, is receiving updates and alerts in terms of fraud on your cards, on your corporate cards, or for your ACH transactions, please make sure that that individual or that team of individuals knows what the filing fees are that will be impacted for your organization. And let them know that the vendor name that will come through is not the same across the board. I have seen different vendor names come through for my clients' applications. So keep that in mind. So that is all I have for you for this Monday morning. I really wanted to concentrate on the H's for the $100,000 fee, and that this week, no more paper to be paying your filing fees. So that's all I have for this week. I hope this has been helpful. If you need help with your immigration work, feel free to reach out to the office. We're happy to help. Have a wonderful rest of your Monday and a great rest of your week.